Welcome back. We're studying again for the real estate test, and today's study notes is about Chapter 2, and the topic is property ownership. And here are today's objectives. Number 1, define and describe the differences between land, real estate, and real property. Number 2, what are the differences between the different systems of home ownership? Number 3, the concept of the bundle of rights. Number 4, how can the government limit the ownership of land? Number 5, what are fixtures? Number 6, what is the difference between personal property and real property? Number 7, what are some of the other ownership rights related to real properties? And finally, what are the different types of properties? Well, it looks like an inclusive chapter, so let's get started. First, real property, personal property, and public property. Well, real property is basically something that you cannot move. It includes the land and everything that is attached to the land, like houses and wells and even trees, and even the airspace and the minerals underground. So I guess if you find oil under your land, then you've struck it rich. So if you own a piece of property, it is all inclusive. Personal property, however, is not real property. It is also often called chattel. If you own something on the land, for example, a decorative lamp, then that is your personal property, and that lamp does not belong to the owner of the property. Even though a lot of times personal properties are sold separately, they can be sold together with the real property. And those types of terms are specified in the deed. And the deed is a documentation that would convey the title of the real estate, as in who the real estate belongs to. And then there is the bill of sale, which explains the sale of the personal property. There is a sales concept called hypothecated. And what it means is that you can use property as security without giving up the possession. And consequentially, the lender would use the mortgage or the trust deed to create a lien against the property. And this way, everyone walks away with something. A public property is a property that is owned by the government. And of course, properties owned by private individuals are considered private properties. Under the feudal system, landowners would pay kings and dukes for their land. Fortunately, that time has passed. Nowadays, we use an allodial system, which guarantees that private landowners have the rights to own their own land. Landowners have a lot of freedom. They can lease, they can sell, they can dispose of whatever they want, as long as it's on their own land. There are some government limitations though, and the acronym is one of my favorite names, which is PETE, only because my dad's name is Peter. P as in police power. So even when you're in your own private residence, please abide by the law. E stands for eminent domain, and that gives the government the right to acquire your private property, but only for the use of the greater good. But you're also going to get compensated for it. The T stands for taxation, and the last E stands for escheat. Some people pronounce it escheat, which is perfectly fine. It's not a verbal test. And what it means is that the government can buy or acquire the title of the land when the owner passes away and has no heirs to inherit it. So what are the major differences between real and personal properties? The differences are circumstantial. Take plants or crops, for example. Now, trees and plants are a part of the real property, but crops are not. And by the way, the technical term for crop is emblemen. Also, trade fixtures are considered personal properties as well. For example, lighting installments or maybe decorations mounted on the wall. And if someone moves after the lease is over, they are perfectly fine taking away the emblements as well as the fixtures. If you want to convert a real property to personal property, there is a way, and it's a method called severance. And oppositely, for personal property to convert to real property, we will use a method called annexation. For example, a fixture such as lighting can become a part of a real property. But of course, there's always a fine line. What if it's this big, huge chandelier, and when you leave a property, you kind of don't have the means to take it with you? So there's a test called MARIA, acronym again, and it stands for method of attachment, adaptation of the item, relationship between the parties involved, intent of the annexor, and the agreement between the parties involved. Now, let's talk about the rights of the property owner. And it's certainly nice to own properties because you have lateral support, which means that you have a right to either side of the land. Adjacent support, and that is support underneath. You also have rights to natural drainage and also the air above you and the minerals below you. As a landowner, you might also have neighbors. So what rights do you have to your neighbor's lands? Well, there's a concept called the easement appurtenance, which means that you have the right to use other people's land if you have the right of way, and that is separated into two categories. Number one is riparian, which means if you share water with your neighbor, then both of you have the right to use it. So if you share, say, a little puddle with your neighbor, then feel free to splash around with that person. Now, the second category is called appropriation. Basically, that means if you have a limited or a specific use for certain water, then you have to apply for the use of it. And I can see that happening in drier states like Arizona or California. Lucky for us, we're in Western Washington. Landownership comes in various ways. Nowadays, a very common way to own land is a planned unit development, where you own your own land, but then you share a common space with your neighbors. There's a townhouse where you share the common walls. There is also co-op where you can own by trust or corporation, but then they would have to pay operating expenses and taxes. And in turn, the owner gets exclusive rights to use his or her unit, and it is called a proprietary lease. And I'm sure you have seen many of them, and some really nice ones in Bellevue and Seattle. And the condo owner receives a deed that conveys it as a freehold estate and has the right to the air above the finished unit, and also a percentage interest in the common areas of the condo building. Unlike the co-op, the condo owner pays their own mortgage, as well as property taxes, insurance, maintenance fees. And if there is some type of lien against the property owner, the lien is not against the whole condo, but just for that particular unit. Last but not least, a timeshare. Most likely you've heard of this as well, where a person pays to occupy a condo unit for a certain period of time within 1 year or within several years. And the fee can be charged in various ways. For example, a vacation license or some kind of membership. It's a great option if you enjoy vacationing in a certain place. And that concludes chapter 2. Next set of study notes is chapter 3, and it's all about estates. See you next time.